The Uganda People's Defence Forces Amendment
Madam Speaker,
Act
order on Honorable
2025.
Kasaija.
Title settled and the bill passed.
Order on...
Yesterday, Parliament passed the Uganda People's Defence Forces Amendment Bill 2025. The bill, tabled by Defence Minister Jacob Oboth, constitutes a major overhaul of the UPDF Act, introducing 84 clauses ranging from structural reforms within the Defence Forces to the contentious provision on court-martial jurisdiction over civilians.
If a civilian kills someone with a hammer, you don't go to the court-martial. If you kill someone with a hammer, a panga, if you box someone dead, you don't go to the court-martial. They take you to the civilian courts. But if you use the gun, if you use the bomb, then that's what. So it's not that the law is saying all Ugandans must be taken to the court-martial.
The bill grants military courts sweeping powers to try civilians under certain circumstances, with clauses 29 and 30 of the bill giving military tribunals jurisdiction over civilians found in possession of restricted weapons or accused of collaborating with soldiers in serious crimes such as treason, aggravated robbery or murder. Today, we caught up with the lawyers to determine whether the law includes provisions that would enable the court to overturn the amendments passed yesterday. The lawyers say that these new amendments will now open a much wider door for civilians to be tried in military courts than it was before the January 31st Supreme Court ruling.
It's tantamount to creating a parallel justice system. Yet the Constitution only sets the judiciary with the core mandate of administering justice. Supreme Court had said that civilians should only be tried in court-martials in those cases where possibly civilian courts would not have jurisdiction. But now they have created a parallel jurisdiction of even offenses which would be triable in the civilian courts. So that is wrong. That is overturning a judgment of court. It is unconstitutional for Parliament to legislate to overturn or defeat a court judgment like they have attempted to do by these particular clauses which open a wider window of trial of civilians.
The lawyers believe the new amendments seem to be politically driven, yet the bill was initially meant to discipline people in the army, not ordinary citizens, unless when there are exceptional cases that may not appear within the realms of the civil provisions before the law.
These conspiracies that have been created in the law, the target is very apparent and it is very clear. It is absurd that this Parliament is now being celebrated by the CDF, as we saw his comments last evening, that it is patriotic. Patriotism still connotes, there is a political connotation in it. Does it mean that people who are not the NRM which stayed in the house are unpatriotic? Is it to say that besides the regime's NRM party, other political parties cannot be part of a patriotic issue?
The legal practitioners also argue that the qualifications of the judges in the military courts are questionable.
The members of the court-martial, as in the bill, while they are lawyers, the chair of the division court-martial is only required to be a lawyer by profession without any experience, and yet judges are required to have at least 10 years experience. And the chair of the division court-martial has powers to even pass a life sentence, even 40 years imprisonment. In the civilian system, only a judge of the High Court has powers to pass such sentences. Therefore, a chair of a division court-martial, at a bare minimum, must also have qualifications similar to those of a High Court judge, which the bill ignores. It simply says, as long as he is an officer holding a law degree and their diploma in legal practice, they are good to go. That is not proper.
The Joint Committee on Defense and Internal Affairs, along with the Committee on Legal and Parliamentary Affairs, took only 1 week to review the bill, which, according to the lawyers, was a short time frame for a thorough consideration of the 150-page document and is incompatible with democratic accountability. The legal practitioners say this will be one of the reasons cited to oppose these amendments before the Constitutional Court. The legislation is now pending President Museveni's signature, a mere formality, considering his outspoken endorsement of the bill. Joram Paul Sonko, for NTV News.